So labor courts are required to look into the correctness of the orders passed by the employers under the Standing Order Act. So every company will have the standing order. What is standing order? Generally, rules which we frame under our policy. Certain rules are given under the standing order that every company will follow. So that are discharge or dismissal of the employee, application or interpretation of the standing order, we can say, legal validity of strike or lockout, and any other matters that are not listed within the third schedule of the ID Act, that all will come to the labor courts. Right? Which matters? Apart from this third schedule of ID Act, all matters like discharge, dismissal, individual, all will come to the labor courts. Power to impose any criminal punishment is only available with the labor courts and not with the tribunal. Such fine or imprisonment penalty, you can say, they have the power. Note, in several locations, labor courts, all courts, and tribunal are combined in the same physical location, and they are referred as labor court cum industrial tribunal. In some city, in some area, they have combination of both at the same premises. So labor court cum industrial tribunal we have. Right? Okay. So what matters will come to the labor court? First of all, under the ID Act. So matter provided for the second schedule in the ID Act within your area of labor court, that will come to the directly the labor court. Which matters? We can say legality of the order passed by the employer, understanding order, the company is saying like this is our rule, this is our rule, we have changed this rule. That rules are as per the standing order or not. So that will come to the labor court directly. Application and interpretation of standing order, again, second point. Yes, that will come to the labor court directly. We can directly complain to the labor court. Discharge or dismissal of workman, employee, including reinstatement, replace of the employee in case, that will come to the labor court directly. And workman wrongly dismiss in case of dismissal, right? So that will come to the labor court. That issue will come to the labor court. Illegality of strike or lockout, there are certain rules, na? If you read the ID Act, if you have idea that before strike you have to give this days of notice, before after giving the notice you cannot go for strike within 2 days, 2 weeks, whatever. There are certain rules, so that will come to the labor courts. And all matters other than the third schedule of the ID Act will come to the labor courts directly. So what we have to do as an HR, as an consultant, as a manager, whatever person you are, right? You are into particular company. So what we have to do, we have to refer schedule of the ID Act. So you will have the better idea. Apart from third schedule, all matter will come to the labor court. And again, any matter specified into third schedule of the ID Act and which is not likely to affect more than 100 workmen can also be tried by a labor court, because standing order is applicable into company where more than 100 employees are there, right? So standing order will be there, we can say. But if your company has less than 100 employees, right? Again, in that case, in that case, this issue will come to the labor court directly. Whether it is into third schedule also, yes, it is fine. That means अगर थर्ड शेड्यूल में जो मैटर कुछ दिया है बट आपके कंपनी में 100 से कम एम्प्लॉई है, इन दैट केस जो इश्यू होगा वो डायरेक्टली लेबर कोर्ट में आएगा. right? Now, what are the powers of the labor code? We can say in the reinstatement, restoring or dismiss or discharge workman to his original employment status. Labor code has a power. They can order to the company employer if employer has wrongly dismissed the or discharged the workman. In this case, if a labor court decide that dismissal or discharge of workman was not justified, they can order for the reinstatement. Specific power of the civil code, like labor court shall have same power as assigned in the civil code under Code of Civil Procedure. In that case, they can enforce the attendance of any person and take examine on oath. And they can call any person and take oath also. Compelling the production of documents and material object for the any inquiry, yes, they can. These are the powers of labor courts. Issuing commission for examination of witness, they can make this, and any other matters that may be prescribed by the government. That all are powers of the labor courts. And a court can order the quantum of cost to be paid by who shall pay such cost in proceeding before it. So court can also order that this particular cost you have to pay to the court. They have the power of the labor courts. ये सब power उनके पास है. Already they have given, government has given this power to the courts, that is labor court. Now next, what are the industrial tribunal and what are the power of the industrial tribunal? So which matters are into third schedule of the ID Act, that is Industrial Dispute Act, will come to the tribunal, industrial tribunal. So which are the matters? Wages, including the period and mode of the payment, cost, hours of work, and rest of intervals. Right? After 5 hours, you have to provide 30-minute break, whatever. That will come to the industrial tribunal directly. If you have 100 and more than 100 employees, right? Leave with the wages and holidays, that matters. Compensatory and any other allowances matter. Bonus, profit sharing, provident fund, gratuity, any method matters. Classification by the grades, A grade, B grade, C grade employee, whatever. Retrenchment of workmen and closure of the establishment, and any other matter as per the third schedule of the ID Act, and you have 100 plus employees, then that matters will come to the industrial tribunal directly. So you will go to the labor commissioner, assistant labor commissioner, factory inspector, whatever as per the hierarchy. They will refer to the top management, and if you is not getting resolved, then you can go to the labor court, or else you can go to the industrial tribunal. Right? Now, दोनों में से कहीं से भी as per the act आप जा सकते हैं. Now, what are the power of the industrial tribunal? We can say same as the labor court tribunal, that is industrial tribunal, have same power as per the labor code. We can say they cannot impose any kind of criminal punishment. Same power assigned into civil code procedure, Code of Civil Procedure. Inquiry or investigation shall be deemed to be judicial proceeding within the meaning of IPC, Indian Penal Code. They can also appoint, if one or more person having special knowledge of the matter for the proceeding, they can make the particular committee or one person they can appoint for the same to investigate. And if during adjudication, tribunal is satisfied that order of discharge or dismissal was not justified, they can order and award direct restitution to the workman. Right? If wrongly dismissed or discharged and it was not justified, they can likely order to the and give award. Award means judgment under the labor law to the workman directly. ये भी उनके पास power है. power of the industrial tribunal. Now, last, what is national tribunal? Under the ID Act, we can say by the central government to address industrial dispute which involves question of a national importance. See, or such nature that industrial establishment in more than one state are involved or affected by such dispute. So if your company is having branches in more than one state, 2 or 3 states, that issue, or maybe issue of the national importance, which directly refers to the national tribunal. So example like closure of the factory of a larger scale employer nationwide. This would affect employment as well as industrial establishment in more than one state. So directly that will be referred to the national tribunal. जहाँ पे इश्यू ऐसा है कि वो इश्यू नेशनल इंपॉर्टेंस के रिलेटेड है और इन केस आपका एस्टैब्लिशमेंट का जो भी ब्रांचेस आपकी है वो एक से ज्यादा स्टेट में है, इन दैट केस वो जो इश्यू होगा ना डायरेक्टली दे विल रिफर टू द नेशनल ट्रिब्यूनल. दे डू नॉट हैव द एप्लेट जुरिसडिक्शन, उनका कोई स्पेसिफाइड एरिया लिमिट नहीं रहता. इफ डिस्प्यूट इज ऑफ द नेशनल इंपॉर्टेंस और more than one state likely to be affected, the central government may refer to the national tribunal. And even if the central government is not appropriate government, then in respect of the industry, again, they can directly refer to the national tribunal. भले वो appropriate government नहीं भी है, again they can ask to the national tribunal. Cognition of offense. How different courts and tribunals take cognition of industrial dispute? It is like essentially means how would a labor court or tribunal or industrial national take note of the industrial dispute? Section 10 of ID Act provide cognizance of industrial dispute through reference by the appropriate government, where appropriate government is of the opinion that industrial dispute exists or apprehended me anytime by the writing. Labor court if matter falls within the second schedule, and tribunal if it is second or some of the third schedule. 100 plus more employee also. Just overview it was. Now PF Commissioner Code, it is also important. EPF Act 1952, they have Central PF Commissioner, it is Chief Executive Officer of Board, appointed, who can further appoint additional Central PF Commissioner, Deputy PF Commissioner, Regional PF Commissioner, Assistant PF Commissioner as per the requirement for the each state. Right? So if an employee has any PF related problem, claim issue, transfer issue, withdrawal issue, directly he or she can approach to the PF Commissioner office. As of now, they have one portal, that is GMS portal, Grievance Management System portal. Na? We can directly raise the issue there. If you're not satisfied with the answer by the online portal, you can reach to the PF Commissioner office of your area or nearby your city, where your company has the code. For non-maintaining of register or not making contribution by the company can be initiated against the company by the PF Commissioner. You can complain there directly for the PF Commissioner or PF related issue. Right? Now, what about the ESI? ESI Act 1948. Again, ESI has the corporation, ESIC, right? That is corporation. Corporation which handles all the matter for the non-payment of contribution by the company and many more. For example, contribution is due from the company and not paid. Corporation can pass the order against the company. They can also seize the property of the company. They have right. ESI have the right. They have power. So now hierarchy of the labor courts, tribunal, national tribunal. Labor courts typically handle dispute of the workmen, employees, and employers. Tribunal handles dispute of the working condition only. And national tribunal for the national importance or more than one state, that will be handled by the particular national tribunal. And matters given in the third schedule before the can be brought before the labor court if workman is less than 100, that we referred into before PPT, right? तो ये तीन मैटर है, वो लेबर कोर्ट में कौन से जाएंगे, इंडस्ट्रियल ट्रिब्यूनल में कौन से मैटर जा सकते हैं, एंड नेशनल ट्रिब्यूनल में कौन से मैटर जाएंगे, राइट? सपोज यूनियन, दैट इज ट्रेड यूनियन, go on illegal strike, directly will go to the labor court, सीधा वो labor court में जाएगा. And worker are not being given their statutory off, that weekly off, matter can directly go to the industrial tribunal or the labor court depending upon the number of employees. 100 से कम है तो labor court में जाएगा, 100 से ऊपर है तो industrial tribunal में जाएगा, right? If number of affected employee is less than 100, matter will go to the labor court. More than 100 employee, that will go to the industrial tribunal. Okay, one latest update. As per the IR code, that is Industrial Relation Code, they have given the limit up to 300 employee. So if your company has 299 employee, there is no such rule that they cannot terminate you. वो कभी भी terminate कर सकते हैं. As of now, it is 100 employee. They have raised the limit of 299. Still, wait for the final rules. And last, if company factory is providing the nationwide employment more than one state, then that particular issue can be challenged to the national tribunal also. So 3 courts, or we can say industrial tribunal, national tribunal, and labor court, where we can go apart from the labor commissioner. That we referred na in first PPT that ID Act के हिसाब से redressal committee within 30 days. What was the question? If company has more than 20 employee, they can have one redressal committee. Every company will have. That is first. This is important for all of us. As per the ID Act, if company is having more than 20 employees, they will require to furnish one committee. That is the redressal committee. Generally, HR will do the same. And they have to do the proceeding within 30 days upon the written application by the employee or behalf of the aggrieved party. And workman who is aggrieved, or you can say is not okay with the decision of the committee of the company, they can go to the against the decision of the company within 1 month from the date of such appeal and send copy to the workman concerned. Means within 1 month, 30 days they have to solve the issue. If they are not, then within 30 days employee can refer this application to the next step, right, to the labor commissioner. And last, as per the IR code, that is 2020, every establishment employing more than 20 employees must have one or more grievance redressal committee for the resolution of the dispute arising out grievances. जिस कंपनी में 20 से ज्यादा एम्प्लॉइज है वहां पे एक आपका कमिटी होना चाहिए. दे विल सॉल्व द इश्यू ऑफ द एम्प्लॉइज. वाइस वर्सा. कमिटी में कितने मेंबर होने चाहिए? इन दैट केस कमिटी विल हैव इक्वल नंबर ऑफ मेंबर्स रिप्रेजेंटिंग एम्प्लॉयर्स एंड वर्कर्स बोथ. And alternatively from employee and workers on rotational basis every year. Every year उसको चेंज भी करते रहेंगे ताकि बायसनेस नहीं रहेगा, राइट? Okay. Dispute for the termination of the individual worker, IR code in relation to the discharge, dismissal, retrenchment, termination of service, individual worker. there are certain provision. You can directly apply to the industrial tribunal for the adjudication. That is first step. Worker may apply to the industrial tribunal within 45 days of the application for the conciliation of the dispute was made. You have time of 45 days. So we can say these are the hierarchy as per the IR code. Request to not touch the screen. Just a minute. What was before? We can have the conciliation, work committee, officer, conciliation board as per the labor commissioner office. Then voluntary arbitration and court of inquiry we have, and then we have adjudication, that is labor court, industrial tribunal and all. That was before. After this application of code, as of now it is not applicable, but still every company will have committee. Then we have conciliation arbitration and directly industrial tribunal and national tribunal. There will be no such labor courts under the IR code. So yes, we'll have the right. We can directly go to the this conciliation officer and directly industrial tribunal under the IR code. As of now, they have not mentioned any labor codes for the any that dispute mechanism, but still we will wait for the final rules. Okay. And right, last point, writ petition. That was your answer, na? Who was asking that if they are not hearing or not giving the proper answer by the labor court, then we have power. After the appeal exhausted and situation where no appeal is specified under the particular issue, or you are dissatisfied, you can file writ petition under Article 226 of our Constitution of India before the High Court. We have power, every employee have. Court will admit only if there is no alternative adequate remedy and legal right of party is violated before authority. They will check first of all. You have referred to the labor commissioner, you went to the labor court, you went to the industrial tribunal or national tribunal. What is the answer they have given? Please come into like in writing and proper documentation. Then they will hear this matter. For example, against order of the Gratuity Act, Minimum Wages Act, EPF Tribunal, against if you want to go of any order, you are not satisfied, then you can enter the writ petition under Article 226 at your particular state high court. Right? That is the power of every employee. Again, last one, writ petition can be filed into Supreme Court also, but only if petitioner can prove that his fundamental right has been violated. Then we can file writ petition into Supreme Court also. But that is the last remedy we have. Before, you have to follow the hierarchy, every labor commissioner, industrial court, court of inquiry, labor court, whatever. A party which is aggrieved by order of High Court can file special leave petition to Supreme Court under Article 136 of our Constitution, which is open remedy for all of particular opposite High Court. Right? If you're not okay with the High Court order, then you can go again there.